The case Haresh Dayaram Thakur vs. State of Maharashtra and Others, decided by the Supreme Court of India on May 5, 2000. Key facts of the case. The dispute revolves around flat number 16/199 at Ramakrishna Nagar, Khar West, Mumbai, initially leased by MHADA, the Maharashtra Housing and Area Development Authority, to a third party. The appellant, Haresh Dayaram Thakur, claims to have bought the rights to the flat in 1989 for Rs 3.45 lakhs and became a member of the Housing Society. His brother, Pitambar Dayaram Thakur, respondent number 3, and Pitambar's wife, respondent number 4, claimed that Pitambar had contributed Rs 1.25 lakhs and hence had a right to the property. MHADA, upon inspection, declared them unauthorized occupants, leading to their eviction under Section 66 Clause 1 of the Maharashtra Housing and Area Development Act, 1976. Legal proceedings of the case. MHADA regularized the flat in Haresh's name after verifying documents. Pitambar challenged this through a writ petition in the Bombay High Court, which directed MHADA to re-examine the claims. Upon re-examination, MHADA again rejected Pitambar's claim. Another writ was filed by Pitambar and his wife. The High Court appointed a conciliator, Justice H. Suresh, retired. The conciliator proposed a settlement. If Pitambar paid Rs 4 lakhs to Haresh, he would get possession, and Haresh would give up his claim to the flat. Haresh objected to this report, but the High Court rejected his objections, making the conciliator's report final and binding. The Supreme Court analyzed the case under the Arbitration and Conciliation Act of 1996, particularly focusing on Part 3, which includes Sections 61 to 81 governing conciliation, rather than arbitration. The key legal issue at hand was whether the conciliator's report could be enforced as if it were a binding judgment or award. This was especially pertinent given that the report was not signed by the parties and its contents were not disclosed to them before submission to the High Court. The Supreme Court's decision was quite clear. Under Section 73 of the Arbitration and Conciliation Act, 1996, a settlement becomes binding only if it is signed by the parties involved. The court emphasized that the conciliator cannot unilaterally impose a binding decision unless the parties have signed and accepted the terms. Since the report in question was neither signed nor accepted by both parties, it did not constitute a valid settlement under the Act. In conclusion, the Supreme Court set aside the High Court's order, stating that it had erroneously treated the conciliator's proposal as binding. The matter was remanded for proper consideration in accordance with the law.